A pleasant day and a warm welcome to your favorite show, Law and Order. So, ladies and gentlemen, we were discussing a series of programs with numerous topics, and today also we are going to focus one of the most important topics when it comes to criminal law. It's bail. So, when it comes to bail, there are certain problems that you will encounter and certain things that you need to know. So, to do the honors with us, we invited Mr. Astika Devendra, attorney at law. Thank you very much, sir, for accepting our invitation and having us in the discussion.
Thank you. Thank you.
Right. Okay. So, and the bail is sometimes be controversial and we discuss a lot. Even in certain offences, we encounter bail. What bail is?
It's not a vast area per se. The basic idea of bail is, now when a person is suspected of a crime or is being tried, he is brought before court or he is arrested. Once he is arrested, one of the most important matters to ensure is that he stands trial. Right? Because the moment you arrest a person, he knows now he is being suspected of a crime. So there are situations where that person might try to evade the arrest and get out of the country or try to hide. So one of the most important issues is that if you are brought before court, to ensure that he stands trial if he is accused.
Right.
On the other hand, there is a question that now there is this principle in criminal law that one of the most important principles is the presumption of innocence.
Yes.
So you can't penalize a person just because he's been suspected. So one could argue, okay, then you are suspected of something, then why don't you keep him behind bars and proceed with the investigation and the trial? So then what happens at the end of the trial or at the end of the investigation, he is released. And then what happens to that time period where he is put inside bars, which actually, even though you don't call it a penalty, he is being penalized.
Yes.
So to harmonize this, you have this concept of bail. That is to, on the one hand, to ensure that he stands trial. On the other hand, to give him his liberties and allow him to enjoy his liberties until the matter is concluded. So to ensure that a person is granted bail upon certain conditions. So basically that is what bail is.
Bail is. And sir, like when it comes to that bail, it's like before the trial that things happen, and it's a procedure that will let out some that will lay out some things that, as you said, the bail is not, although it's not a vast area, it's a simple, not actually a simple, but a certain defined thing when it comes to a certain court proceedings, and presumption of innocence, as our guest said. So it is a most important thing when it comes to certain considerations, and when it comes to the fundamental rights also we'll be discussing that thing a little bit. And so some offences, they can be granted bail, some not. Bailable and non-bailable offences. Can you explain something on that?
Before I get to that, can I just clarify something?
Better,
in your when you just addressed the audience, you said that bail at the time of at the time that the person is suspected and the trial is proceeded. No,
Yes.
not only that. There are different scenarios and different situations where bail is made use of.
Right.
Firstly, now since this is not for academic purposes but for the masses, for them to get an understanding. I will speak of the Sri Lankan system.
Yes, better.
Now, with the Sri Lankan system, if a person is suspected, that person can be granted bail in two forums. Either I will try to link that situation with the questions that you just posed.
Better, sir.
You can either be granted bail by the OIC or the police station, or you by a court.
Right.
First, whatever the crime it may be the most the grievous of the crimes, the most grave of crimes, but still for all you are brought before the magistrates court in Sri Lanka. So then you at that point you are only a suspect. Why? Investigations are pending.
Right.
Then you become an accused at a particular point of time. That is when you are charged.
Right.
Then you can be charged depending on the gravity of the offence, either in the magistrate court or in the high court, in the Sri Lankan context. At that time, you are given bail. First you were given bail as a suspect, now you are being given bail as a accused, right?
Right.
thirdly, if you are convicted, okay, then you are convicted, you appeal, right? You appeal to a higher forum. What happens in between, right? So then, even though you are convicted, still there is something called bail pending appeal. So these are these three stages where bail is generally given. There are other stages also.
Yes.
To the question that you just posed, that is, what is bailable and unbailable? Right. Now there was a very clear definition prior to the coming of the Bail Act, which is 1997 Act. There was a clear definition, distinction. Right. But however, now that distinction had more or less overlap. Anyway, as far as the viewers are concerned, if you are charged with a bail, now the basic rationale is a bailable offence is in gravity, in seriousness, it's less. An unbailable offence, the seriousness is more. Right? So a bailable offence at present, or even in the past, it was easy for you to get bail. Initially, before the Bail Act, if it was bailable, you got bail. But now it's not so. Even for a bailable offence, the magistrate can refuse bail. But for a bailable offence, the officer in charge of police, now if let's say I am suspected of a bailable offence, I am arrested with the police and taken to the police station. The officer in charge of the police station can grant bail, right? But for an unbailable offence, the officer in charge can't do that. He has to bring the accused, arrest the person and bring him to court. Now, or even for a bailable offence, he can do the same thing.
Right.
Once he brought before the magistrate's court, then the magistrate court, irrespective of whether it's bailable or unbailable, can grant bail. Right? But remember, there is there are some offences where there is no bail. For example, if you are suspected of a crime committed under the Prevention of Terrorism Act, there is no bail. Right? So you have bailable, non-bailable, no bail, right? And there is another set of offences where you can get bail, and not from the magistrate court, but from a higher forum, that being the High Court. For example, the Bail Act itself says, if you are charged with a crime which is punishable with death or life imprisonment, then you can only get bail from the High Court. So that is also there. And there is another set of offences where you can get bail either. It depends on the particular offence. If I am making it more confusing for the viewers, please tell me.
Yes,
right?
no, it's okay. We can continue.
No,
because it's really interesting, the diverse area that we are going to maneuver.
Yeah. So we have bailable, non-bailable, no bail, bail only from the High Court, and there is another set of offences where you, depending on the offence, you can get bail either from some cases you can get bail from the magistrate court, some cases you can get from the High Court. But the law dictates that you need exceptional circumstances. Now, for example, just going and asking for bail is not, you will not do.
Yes,
right?
not entertained.
Not entertained, not in the sense they will entertain the application, but you will not be given. So, exceptional circumstances you have to prove, right? So that is my confusing answer to your simple question.
Right, okay. So we discuss about numerous areas. It's not the simple thing, bailable and non-bailable. Sometimes there might be no bail, for example, so prevention of terrorism. And so like we come across the Poisonous Opium and Dangerous Drugs Ordinance, like PODDO, the Act. So it also says that the offences come under that thing are not bailable.
No, anyway, it's non-bailable. But remember, just because you say non-bailable doesn't mean that you can't get bail. But the problem with those offences is that if depending on the quantity, for example, heroin more than 2 grams, the magistrate doesn't have jurisdiction to give bail, because why? The penalty is attached to that offence is life imprisonment. Life imprisonment. Right. So if it is life imprisonment, you have to go to the High Court and show exceptional circumstances. That is what is stated in the Poisonous Opiums and Dangerous Drugs Ordinance. Yes,
okay. So you might be having certain numerous answers with regard to different readings, but we are talking the practical scenario. It's just some offences you can get bail, some they might not, and no bail actually, and there are special circumstances, and some magistrates court not granting bail, a superior court will grant bail. There are numerous things. And so like when it comes to the types of bail, there are sureties, money. That can you just explain and it a beautiful answer for that as well?
Thank you for saying that my early answer was beautiful. Now it's like this. Now, the basic idea is that if you are given bail, that means you are letting him out. You must ensure that that person is brought. So, according to the Bail Act, there are several types. Most commonly, what we see is you can have what is called, you can release a person on his own recognition. That is just to say, you go and say, okay, I recognize that you will not, evade arrest. So, you are given bail. Let's say you are allowed to go. Or you can be you yourself be able to sign a bond, right? To say, okay, I will ensure that I will come. The bond is, let's say, 100,000 rupees. But by any chance, if he doesn't go, if he doesn't come, and he's caught and brought, he is liable for that 100,000. So that is his personal bail. Then you have surety bail. That is, let's say I am arrested. You come as my surety, and you assure to court, look, I will assure that he attends court. And if I don't do that, I am liable to pay 200,000 rupees, right? So it will read as surety bail. You are my surety of 200,000. That is, you don't have to pay the 200 at that time. But if I evade arrest, then you come to court, you will have to pay the 200,000. Then there is cash bail, right? Cash bail is, I am released, and then I have to deposit 100,000, and if I don't, if I am acquitted and if I am convicted, I can get that money back. But if not, if I doesn't attend court, then that money will be confiscated. There is something called certificate bail also that is not relatively used in Sri Lanka. These are the main types of bail that is used.
Right. When it comes to a particular reading with this bail, so what I understood with some questions from the general public, some people ask me like, what is this, what is personal bail, what is surety bail. Some people try, for example, if I am convicted of a crime, so if I am arrested, so I need a surety bail. So my brother, I take him to the court and I just ask him to appear on behalf of me like 200,000 surety bail. So that is only the sum that they need to pay, and some misunderstand that thing as they will be arrested on behalf of me. Does it happen?
No, in the sense like they will be put in trial, you mean?
Yes.
No, there is no such thing. They don't even have, the only thing that will happen is if as you said in your example, we'll take the same example, you don't stand trial, you abscond, they are brought to court. First they will be summoned. If they come, that's fine. If they are not summoned, they will be warranted and they will be brought before court, and they are allowed, that 200,000 also not confiscated then and there. They are asked to show cause why that money amount should not be confiscated.
Right.
If it is not confiscated, this is why where it gets tricky. If they pay up, that's issue, no issue.
Right.
If they don't pay, the court has to go behind the assets.
Right.
So let's say your brother has a car, they can confiscate a car, sell it and set off that 200,000.
Right.
If that also cannot be done, after inquiry, they can be given simple imprisonment. Right. But if you pay the money, or if the money is recovered, there is no issue.
No issue. And so the other thing that, as you said, in a certain case that we are not produced and we are just evading certain steps, they will confiscate the money. Otherwise, that we can obtain the money back. So what is the procedure there?
Yeah. So what happens now? The surety, there is bail is kept. The matter proceeds to trial, let's say, or several things can happen. He can, even at the investigation stage, the prosecutions can come and say, look, we are not going to proceed with the matter, and this person can be discharged. Or after trial, he can be discharged. Once he is discharged, or he can be even convicted. Right? Once all that happens, now there is no need for bail. That money will be given back to whoever deposited that sum.
Right. So that will be given back.
Yeah.
Right. Okay. So there might be certain like silly questions that I will be questioning, but that is from the general point of view that normally people, they does not know the in-deep study of these things, but they just fall in trouble with these simple things. So you must know each and every small thing, because not knowing the law is not an excuse, that I'm always saying. So in our programs we concentrate on those specific areas as well. So we discussed types of bail and even certain other offences with regard to bail, and those certain areas as a particular introduction. And so let's take a small case, for example a practical scenario where I am convicted and I need to have bail. So the time period, the procedure, can you explain that as well?
You're convicted.
Yes.
Right. Now if you are convicted, then you can be convicted in two courts, so I'll have to take one at a time.
Better.
Magistrates court, the maximum sentence. Now if you're given a fine, there is no issue of bail.
Yes.
If the maximum sentence that can be imposed is 2 years, but if he's charged for several offences, maximum of 4. So then you appeal to the High Court. Generally, if magistrate, I'm on a practical point.
Yes.
Generally, if you are convicted in the magistrate court and you prefer an appeal, you file the appeal papers in the magistrate court. The magistrate not automatically, but upon application generally grants bail. Why? Because let's say you are sentenced of 2 years. When the appeal is taken up, it will be another 1.5 years, 2 years after. So if he is put inside bars, that doesn't make sense for him to stand trial. So the bail, you file the papers in the magistrate's court, the appeal papers addressed to the High Court, and you ask a request from the learned magistrate, and he will generally grant bail. High Court is different. High Court, you don't have such a right. High Court, if you are convicted and your penalty is death or life imprisonment, there is no bail. For whatever reason, you can't get bail. But in other situations, if you, now at one point we will discuss what exceptional circumstances are, but if you show exceptional circumstances, that will, the High Court can grant you what is called bail pending appeal. Right? But it will take some time. It's not just filing of paper. You have to file a different petition, what is called bail pending petition, appeal petition. The state can object to this, and then upon inquiry only you are granted bail.
Right. Okay. So let's move with that exceptional circumstances as well.
Okay. Exceptional circumstances. Now we find this word in relation to bail in different situations. Now, as I said earlier, even at the initial situation, there are certain offences. If you are suspected of that offence, you are brought before court, you need to show exceptional circumstances to get bail. And I just said, if you have been convicted in the High Court, to get bail pending appeal, you have to show exceptional circumstances. Now, there is no clear definition in the law books or otherwise to say what exceptional circumstances are. But what the authorities have said is that exceptional circumstances will differ from on a case-by-case basis. But if I were to give you examples of what exceptional circumstances parties agitate before court, one could be a health condition. Right, a person is put inside. He has a serious health condition. That could be one, or a health condition of a family member, or as I said, now generally, if when you're convicted of in the High Court, if the sentence, let's say, is very minimal, the sentence is 2 years. If bail is not granted, by the time the appeal is taken up, that sentence he will be inside. So it can depend on situation to situation. Even though it was not considered per se, even COVID-19, right? I mean, nobody gave a ruling to say that, but it was in the back of the mind of everyone that at that particular point of time, overcrowding of prisons was an issue, right? And putting someone inside at that point of time would not only endanger himself, but endanger that person's life, but endanger the other imprisoners as well, other prisoners as well. So it can differ, but in a very explanatory way, those are the examples I can give you.
Right. Okay. So will that cause an infringement of fundamental rights?
What will cause?
Not granting bail.
No, it's now Article 14 speaks about this individual freedoms and your right to have liberty and the right for movement. All that is there enshrined in Article the 14, and Article 13 also says specifically that you have the presumption of innocence and so on. However, I believe it's Article 13(5) which specifically says that incarcerating a person or committing a person to custody either at the investigation stage or at the trial stage or upon conviction will not constitute an infringement. So that has been made clear. But I understand your question. The question is, now while you say there is presumption of innocence, while you say that he has right of movement within the country, how can you incarcerate a person? But even though the rationales sort of overlap, the Constitution specifically says that it is not in violation of the fundamental rights.
Right, okay. And sir, like in certain cases, I might be caught red-handed, and there might be a possibility that a reasonable thing to the courts or the police to believe that I might interfere with the evidence pending with this case. So in certain cases, the bail might be granted. So in that case, can we prove our innocence? No, I'll not interfere with these the evidence, and although I'm caught red-handed, that is not my fault. Likewise, what is the defense, or how can we prove our innocence to get bail?
Yeah, I think we are at a very important point. I will explain something else and then come back to your question.
Yes.
Now, when you ask for bail, if the Bail Act comes into operation, there are certain things that the judge has to consider, either granting or refusing bail. Right? That is in Section 14, the judge has to consider 4 important facts. One is whether he will stand trial. That's the most important. Second thing is what you say, whether he will interfere with the investigation. Right? Third thing is whether he will commit another offence while on bail. Right? Fourth one is whether there will be public disquiet. Right? Now, first one is very easy, whether you will stand trial or not, whether he will evade arrest. Second one is that whether, now for example, let's say now if you and I are arrested, we might not be able to interfere with the issue. But let's say a police officer or a person, let's say let's say that the crime that you're charged of is corruption or bribery for that matter, and then the entire evidence or the persons who are going to give evidence, the documentary evidence is in the workplace that he works. Right? So in his department. So if he is allowed to go out, he might try to interfere. He might take out the files or do those things. So like that, or he might speak to those people and say, don't give evidence against me. So that, or if he's, let's say he's a thug, he might try to threaten people and say, look, don't give evidence against me, otherwise I'll take action against you. So that is the second one. Third one, let's say he's an habitual offencer. We call him a habitual offencer. Or let's say for who have committed many drug related offences. Then you give him bail. Now 1 week he comes, he is given bail. Next week also he is caught on board for the same offence. So the judge can consider that. Third one. Now, for example, we know when there are at least child molestation issues and so on, if a person is given bail, now child is molested or child is, let's say, unfortunately murdered by someone, that person is suspected, is taken out, and he is given bail and they are in the same area. If he is given bail, then there can be public disquiet. I mean, there are two sects, one party could harm the other. So those are the matters which can be taken into consideration. So, judge, your question was, if the police says, what can I say? So of course what we can say is that won't happen. So what the court does is, if there is such a situation in granting bail, court ensures that and tells that person, warn that person, sometimes even record it to say, don't interfere with the investigation.
Right. Okay. So as we are running out of time, we are about to conclude the episode. But one last question, sir. certain conditions or certain other things might be expected by the court, interfering with the evidence and not committing a crime of the same caliber or any other crime, those things. So if I do that thing, if I if I'm not going to obey those restrictions, what will happen?
Once it is reported to court, court will definitely, not definitely, but court can do so. Now, that is also important fact. That is that court at any time after giving bail can rescind its own order after giving reasons. So the reason is, if the reason is violation of the bail condition, the court will record that reason and rescind that order.
Right. Okay. So thank you very much, sir. We had a fruitful discussion about bail and certain consequences, how to apply and what are the consequences, after effects, and certain legislation and the pieces of law that we need to have a certain idea with regard to the law with regard to bail. So thank you very much, sir, Mr. Astika Devendra, attorney at law, for joining us with today's discussion. And stay tuned with Law and Order. We'll be discussing numerous topics in the future as well. Have a pleasant day. Thank you very much.